Matter before the court this morning is the case entitled Adriana Cunha-Salomon et al. Versus Williamson Group LLC, doing business as Williamson Group Sotheby's International Realty, case number 24 AP 309. Appellant Adriana Cunha-Salomon is self-represented and is appearing here by video. Representing the appellee, Williamson Group LLC, is Robin Cooley.
Thank you. All right, appellant, you know you have 5 minutes. You might have reserved some time, but in any event, we'll let you know when you're running out of time. So you may proceed.
May it please the court. I am Adriana Cunha-Salomon. I'm pro se, and I'm representing also my son Gabriel. This case is about an application of the rules relating to service. Those rules are 3A and 6B, 1B. The trial court has discretion to not require strict application. The definition of service on the court's website is providing a party with pleadings, putting the same party on notice that a court will decide a matter of affecting their rights. This happened. The complaint and the summons were mailed to the defendant. And approximately 30 days later, I received a letter from the defendant's lawyer, date March 31st, page 9 of the print documents, which state that, number one, Attorney Cooley read the complaint. Number two, she represents the defendant. Number three, she raised substantive defenses. Number four, she threatened a motion to dismiss. And number five, she proposed mediation. I reasonably thought that we were proceeding both in good faith. On May 30, more than 60 days after I sent the complaints to the defendant, we in fact went to mediation. And the defendant made an offer and did not in any moment leverage their position by raising lack of service. Under all those facts, Your Honor, and looking to the definition of service and the Vermont Judiciary Mission Statement for Guidance, restoring this case to the docket is the only resolution which protects my rights and allowed fair resolution and a day in court. In my understanding, Your Honor, those rules are intended to be a tool to administer justice, not by any means weapons to deny it. And that's all I have to say.
Okay, thank you very much. The attorney for appellee Could you please identify yourself and begin?
All right, I'm sorry. Did you say the attorney for Williamson Group or?
Yeah.
Oh, I'm sorry, I
appellant.
misunderstood you. Thank you. My
Okay,
name is Robin Cooley and I represent Williamson Group.
thank you. Go ahead.
Thank you. Good morning. May it please the court. My name is Robin Cooley. I represent Appellee Williamson Group LLC. The trial court did not abuse its discretion in dismissing this case because appellants did not serve the Williamson Group within the time and the matter that is required by the Vermont Rules of Civil Procedure. Pro se litigants are still held to comply with the procedural rules, and appellants.
The initial complaint was filed by with service by mail. And was there ever an acceptance of that service by mail or a return of a certified mail receipt?
No, there was not. So the original, just to be clear, my understanding is that that appellants filed their complaint initially with the Superior Court, and that was filed with the Superior Court on February 14th, 2024. Then on February 28th, 2024, there's a letter by that date that is sent by the appellants to Williamson Group, enclosing a copy of the complaint, purporting to enclose a copy of the waiver of service, but in fact, no copy of a waiver of service form was enclosed. Nevertheless, the letter said, and this is very important, it shows that appellants knew that they had an obligation to serve, knew how to serve, and knew what a waiver of service was. The letter said, if you choose to waive service, please do so within 30 days. If we have not received the waiver of service by then, we will proceed to have you served by a duly authorized sheriff or constable. They used the exact forms that are provided by the court. So they understood that service required either the voluntary acceptance through the form of the waiver of service, or that they needed to serve by a sheriff or constable, and they did not. Also, to be clear, further to that point, my correspondence to the appellants pointed out that the need for pre-suit mediation was required by the purchase and sale agreement. Therefore, we were not engaging in we did not at all purport to be pursuing or participating in a post-suit mediation. This was a pre-suit mediation as required by the contract, the purchase and sale contract. The court correctly ruled that late is late. The appellants did not serve Williamson Group within the time required by the rules. In fact, they did not serve Williamson Group until 149 days after they filed their complaint with the trial court. In addition, there was no excusable neglect. The trial court correctly ruled that the appellants did not show this. The ability to serve was entirely within the control of the appellants, and their own communications show that they understood how to do this. Moreover, the rules provide that pro se litigants are still responsible for complying with those rules. There's nothing in the court's communications or in the rules that suggest that information contained on the judiciary website replaces the service requirements that are contained in the Vermont Rules of Civil Procedure.
Either by mail or by service from a service provider, sheriff or constable.
Correct. Although to be clear, for service of a complaint by mail, there would then need to be a return of the waiver of service.
And they're also talking about it's a complaint and the summons. It has to be both, right?
Yes, correct. In this case, the appellants showed that they knew how to do this, they understood they had to do it, and they failed to do it. And there was certainly no unfair inducement made by my client to cause them to believe otherwise. That is factor 3, which is that the failure to serve was entirely within their control. The other factors, 1, 2, and 3, are equally satisfied, particularly the danger of prejudice, the considerable delay, and good faith. Finally, there's the sorry, there was no unfair inducement, and this was entirely through the appellant's own omissions and inadvertences. Therefore, we respectfully request that the trial court's decision dismissing this matter be upheld. Thank you.
Okay, thank you. I don't see any further questions. Does the appellant have time remaining?
Yes, the appellant has 1 minute remaining.
Okay, ma'am, you may go ahead and argue for another minute if you'd like to. Ms. Cunha-Salomon?
Yes.
Yeah.
I'm just reading my notes.
Okay,
I filed a motion when Attorney Cooley did not accept service. I filed a motion to clarify it with the court. And the motion to dismiss never happened. She never filed a motion to dismiss the case. And I followed the website guide and I thought I did everything that I supposed to do. The court, everything of course is that I don't want to waste my minute, but everything is addressed in my brief. But basically the court got wrong because they did not consider
Appellant has no time remaining.
the entire letter of Attorney Cooley, date that is in the printed case, date March 31st.
okay, thank you. Your time is up. All right, thank you for participating in this hearing. We'll be sending an order to you forthwith.
Thank you so much for your time. I really appreciate every